ask you to comment on any potential loss of status, but have you...
Rise, Mr. Chairman.
Have you anything else to add in general terms?
Well, the question of transferability is another issue which is being considered by the current review, the, if you like, mutual recognition of qualifications. Again, I would anticipate that the committee may hear more about this in due course.
Yes, indeed. Sorry, Mr. Motion.
Convener, can I just come in at a point of clarification there? The Society of Solicitor Advocates is a voluntary organisation. We don't have a formal regulatory role in the regulation of solicitor advocates at all. And for the committee's information, the current split of our membership, I believe, is approximately 60% civil practitioners, 40% criminal practitioners.
Thank you. Robert Brown.
Just one brief question on a slightly different issue of non-lawyer ownership of legal firms. Now, the faculty set its face in its own instance really against that sort of proposition. I wondered if you could just give us an idea of your thinking about the risks associated with that from your respective potentials, if you will.
I think that there are potentially very real risks, and you may be aware of the Bain report in Northern Ireland, which concluded that really the risk there was very significant. Now, largely because of the historic background there, but they were very concerned that firms of solicitors would come to be controlled by factions within the background or shadows of Northern Ireland politics, and that caused a great deal of concern. And you can put up safeguards, but as soon as you put up a fence, somebody can find a way around it, over it, or under it. And I think Professor Patterson candidly acknowledged that. You've got shadow directors, shadow owners. It's very difficult to regulate. I believe that there is a real issue there. The question, I believe, if I can put it back to you as a political one, is the risk such that you don't take this step so far as outside ownership is concerned? And I would have a concern there for the Scottish legal profession, although it doesn't impact on the bar. One concern I would have is that if we don't embrace this model and the larger firms want it, they may be tempted to effectively reincorporate themselves in England. And we don't want to see that.
Does that work both ways? I mean, there's risks being expressed as well about the potential for English firms, if you like, taking over Scottish firms, and the same end result would emerge out of that if the whole idea of multidisciplinary partnerships was allowed to proceed.
Well, to the extent that English firms want to take over Scottish firms, they do it already. Mr. Marshall will be able to confirm that there are two parallel partnerships, Thompson's England and Thompson's Scotland. And no doubt they're entirely separate legal entities, but in reality they operate in close cooperation. So that can be done. I don't think that there's a very real risk of English firms storming in and taking us over. I actually believe we can fight our own corner as long as we deliver the service that the consumer and the public need and want and provide suitable means of access to justice. We will be able to maintain our independence. My greater fear is that if you have a business model available in England and you don't have it available in Scotland, there will be a temptation for some of the larger firms to say, I think we'll go down and join the English Law Society and leave the Scottish Law Society. And that wouldn't be a good thing.
Mr. Marshall, have you got views on that?
Thank you. I'm less concerned, I suppose, about the involvement of lawyers from other jurisdictions. I hasten to say that Thompson's Scotland and Thompson's England and Wales, although they bear the same name, no longer have any relationship. Once upon a time, they had a closer relationship than they do now. Yes, we have mutual clients, but we operate entirely separately. The particular concern I have, and I would hark back to something that was said earlier about the question of perception. If you had a situation where there was a firm which was owned, it was one of these new licensed legal service providers which had outside ownership, and that firm was acting for a particular client in a court case, and in due course, the case was lost. And afterwards, the client discovered that the owner of his law firm had a financial interest in the opponent in the court case. Now, the lawyer who'd been handling the case might have been entirely oblivious that this situation existed. But from the point of view of the client, there would be a perception that somehow the service which he had received had been tainted by the relationship between the owner of the law firm and the opponent. So, as I see it, at the moment, what the bill is doing, and we've referred to it in our paper, Section 51, what that is doing is saying that owners must behave properly. It's telling them that they mustn't actively take steps to impinge upon the legal work of the organisation. But in the example I've quoted, they wouldn't be taking any active steps. There would simply be a passive situation which existed. And it seems to me that the bill doesn't deal with that particular situation. And in my respectful view, it should.
Any other questions? There being none, can I thank you very much indeed for your attendance this morning. Committee will
receive us and listen to us.
Always a pleasure, Mr. Keenan, always a pleasure. Committee will suspend briefly. Committee will reconvene in order to deal with item number 4, which is an item of subordinate legislation. There is one negative instrument for consideration today, the Justice of the Peace Courts, Sheriffdom of North Strathclyde, etc. Amendment Order 2009, SSI 2009/409. May I draw members' attention to the cover note, which is paper number 4. The Subordinate Legislation Committee did not draw any matters to the attention of the Parliament in relation to this instrument. Do members have any comments, or are we content to note the instrument? The instrument is noted. The committee will now move into private.